Thank you all for coming to this wonderful webinar today. We are honored to have Judge Jackie Connor in attendance, answering some questions for us today and teaching us about the judiciary. My name is Tom Cavanaugh. I am a 3L at the USC Gould School of Law, recently known as the Zoom School of Law. And before I introduce Judge Connor formally, I would like to lead us in a quick prayer. In the name of the Father, Son, Holy Spirit. Amen. Heavenly Father, thank you for this opportunity to come together and learn about the judicial system in the great state of California. Thank you for the enduring goods of justice and truth, which we only find in you. Please give our leaders and judges the fortitude to seek justice and truth with integrity, and please give us the appetite to ardently seek these goods in our own lives. We particularly pray that our judges and leaders will further the dignity of all human life, and we pray for those who, like our Savior Jesus, suffered the degradation of unjust accusation. For these things we pray in your name. In the Father, Son, Holy Spirit. Amen. Now it is my sincere pleasure to introduce our esteemed guest, the Honorable Jackie Connor. Judge Connor is a distinguished jurist who, in an impressively diverse array of legal offices, has honorably served the state of California and its citizens. From 1977 to 1986, Judge Connor worked for the Los Angeles District Attorney's Office, where she served as the head of the sexual assault unit. Judge Connor began her career on the bench in 1986, where she nobly decided cases as a judge on the Los Angeles Municipal Court. In 1988, Judge Connor was appointed to the prestigious role as a judge on the Los Angeles Superior Court. In that capacity, Judge Connor honorably presided over cases for 24 years. Her integrity and intellect have earned Judge Connor national recognition, including awards such as Top 100 Judges in California in 2007 from the Daily Journal, Leading 500 Judges nationwide in 2006, Outstanding Jurist of the Year in 2006 from the LA Bar Association, Judge of the Year from the Century City Bar Association in 2000, and Judge of the Year again from the LA Bar Association. Judge Connor has relied on her extensive judicial experience to resolve complex legal and factual issues as a mediator since 2012. Thank you for joining us today, Judge Connor.
You're very welcome. It's my pleasure. Actually, it's 25 years. I want that last year, especially since I nobly served and honorably served, which is interesting because it's funny in my world on the bench, it's like we make permanent enemies and temporary friends because every single decision we make, somebody disagrees with us, somebody on the other side, right?
Yeah, I imagine that's the name of the game.
That's the name of the game. So yeah, I nobly decided cases half the time.
Okay, according to half the people, right?
Yeah.
So, Judge, we're looking forward to hearing about your professional experience and the ways your Catholic faith has informed your decisions. But I was hoping maybe that you'd be able to tell us a little bit about the technical details of the judiciary and your role first. So, most basically, would you be able to please walk us through generally what is the judiciary? What's that phrase mean when you refer to the judiciary?
Okay. Pretty easy. It's one of those things I think we learned in maybe fourth grade, but our government's made up of the three branches. The executive branch, which is the president, that's also the enforcement branch. The legislative branch, which is Congress, they make the law, they legislate. And then the judicial branch is the one that decides whether or not we're all fitting within the Constitution. So we don't make the law, we don't impose the law, we just decide does it fit within the framework of what our Constitution and the presidential law is made up of. So the way it's set up, we have a federal system and we have a state court system. I was in the state court system. On the federal system, you have at the very top the U.S. Supreme Court, and that's been in the news lately with the confirmation hearings. But there's, when full, it's 9 justices. There are 179 courts of appeals, only on the federal side. There are 673 district courts and another 9 international trade courts. These are all on the federal side. So in terms of the ballots, you're never going to see these people on the ballots. It's an appointed position. It's a confirmed position. They deal with things that are federally oriented. In other words, it crosses state lines. It could be immigration type issues, bank robberies across state lines. It might be some criminal and civil international type things that can't be confined within the laws or the confines of a state.
So I think, Judge, if I could, I think people would be interested to know that emphasize what you're saying there. Federal courts they're not allowed to hear all cases. That's correct?
They don't hear all cases, right. It's kind of split up with what fits within the state law. We have our own court system, and it's a little mini version of the same thing. We have a California Supreme Court, we have the appellate courts, we have the trial courts, and in the federal system, it's the district courts are their trial courts. So they're kind of doing the same function. The type of cases they deal with is completely different.
Now I think that's interesting, because I'd imagine a lot of people would be interested to learn how important our state courts are because of how much their general jurisdiction plays in. It's
in our lives. It's in our lives. So it started out, we used to have 2 trial court levels, municipal court, and then superior court, and it all got molded into one some years ago. But at the top of the ladder is the California Supreme Court. And unlike the U.S. Supreme Court that has 9 justices, we have 7. They always make it an odd number because they certainly don't want a tie. You can't have a tie.
Right.
What good does that get you? And interestingly enough, it's funny because at the point where we're still looking to see if Judge Barrett is confirmed or not, or Justice Barrett is confirmed or not, if the Supreme Court is tied or doesn't make a decision, it doesn't mean nothing happens. It means whatever the court case was, whatever the trial court was that decided that issue, or the appellate court that decided that issue, stands. So whoever didn't like that decision and then appealed it all the way up to the Supreme Court, and the Supreme Court doesn't deal with it, it doesn't mean it's not decided and they're off the hook. It means that whatever the last decision was stands. So it's important that they make a decision.
And Judge, I was wondering, would you be able to explain the difference between having general jurisdiction at a trial court, having appellate jurisdiction at the courts of appeals, and then, like you're saying right now, having what people would sometimes call the discretionary docket? And maybe at the Supreme Court level, how many cases are they hearing out of the cases that petitioners seek to be heard?
Yeah, I didn't look that up, but it's a fraction.
Yeah, it's very low.
A fraction. It's very, very low that they accept. And that what'll happen is that if they don't accept a case, the appellate decision stands. They accept very, very few, and they want to make sure it's something. For example, if there's a split between the appellate courts as to this court says this is the definition of a contract, another one says no, it's a little more expansive, and it's creating a problem in our world because we have to know what the law is. That's the kind of case they will probably take. Or there's something of first impression that hasn't been decided on, but it's done very carefully and very selectively when they choose to take a case, because it creates precedent. It creates a whole new set of precedents. So on the state court where I was, we have 58 counties, in case anybody didn't count recently. That means we have 58 superior courts, LA Superior Court, Santa Barbara Superior Court, San Francisco Superior Court, all the way up. We have 6 district appellate courts in LA, but basically there are 179, there's 105 justices and a total of 2,175 commissioners, justices, or judges in the state of California. There's a bunch of us. That goes all the way up from small claims, where we often have pro tem. We have attorneys who volunteer. It's commissioners who apply as a job. You can just apply as a job to the court, or you become a judge to get to be a judge, of which we have 600 of us just in LA alone.
Wow.
It's the court system in the country.
And it's my, I was going to say, it's my understanding that the California judicial system is the busiest in the world, and in particular, LA is the busiest in California system.
Yeah, it is.
That's where you were. So you were really right in the middle of it.
Right. So we're flooded.
Yeah.
A lot of work. A lot
So,
of work.
Speaking of these claims, I hope it's okay. I'm gonna put forth a little hypothetical here to see how things move through the system. All right. So let's pretend that I'm arrested for stealing Father Richard's expensive golf clubs here at the Catholic Center. They've got me on tape. They find the clubs in my apartment, whole 9 yards. But I really think I'm innocent, and I've heard that I'm entitled to my day in court. I'm looking forward to proving my innocence. What's my next step, and what are the odds I actually end up in court at a trial?
Okay, so the first thing you're positing is you're expressing or give me an example of the two different parts of the court system. One is criminal, one is civil. So what you're talking about is you're arrested, it's a crime. You got arrested for a crime, you're going to be charged with the crime by the state of California or the people of California. It's not just a person suing you, it's not Father Richard suing you, it's the state, because they represent, in a sense, the people, they represent the victims.
Okay.
On the other hand, Father Richard could also sue you, and that would kick you over in the civil side because you could get hit twice, so double whammy, depending on whether.
It's kind of what the O.J. Simpson trial is a famous example of that, right?
Yes, yeah, it's not unusual. It's most frequent if there's what we might call a deep pocket. If there's money to be had, there's more likely that there might be a civil suit. If there's no way of collecting against somebody who doesn't have resources and assets, I mean, what's the point? It's not going to happen. So in your case, so you get arrested. The law enforcement will take, depending if it's a misdemeanor or a felony, they will take it to the DA's office in LA, or they'll take it to the city attorney. If it's minor, if the Gould golf clubs are worth, $10,000 or they're only worth $600, that depends on where the cops will go. They will go to the DA's office. It's the 10,000 side. They'll go down. If it's a minor, it's a petty offense. If it's, you got his raggedy ones. You thought they were the gold ones, but it turns out that he has a fake raggedy set. You got the raggedy set. Goes to the city attorney. The city attorney's office then gets presented with the evidence, and they'll make a decision whether or not they're going to file it. If they file it, they will file it, and it gets into the court system. If they don't file it, it just goes away. The arrest goes away. You'll still have an arrest on your record, by the way. That's going to be there forever, unless you try to expunge it.
I noticed recently I've been filing my bar application, and I'm required to disclose if I've ever been arrested, even if
not convicted.
Dismissed.
Yeah, there's certain bonded positions that you have to disclose no matter what. And even if you try to expunge it or have the case taken off the system, so to speak, there's certain applications that you'll go through. If you're with children or you're in a bonded position, you have to disclose it, or you're kind of in trouble. So if they decide to file the case, then it gets filed in the court. You have to have an attorney. You have to either provide your own attorney. You can find your own if you can afford one. If you can't, the public defender will represent you, but you will have representation in the court unless you refuse it. You can refuse it, what we call a pro per. You can decide, I want to represent myself. I don't care what you say. And the court has to approve that, by the way. We can say no.
Do you recommend that? In your experience, would you recommend that? Or
never.
Okay.
Never. There's too many little pitfalls that you can fall into and end up losing your case in a technicality, because, I talk about this with the mediations that I do now. The law is objective. Okay, so if there's a definition of an assault with a deadly weapon, somebody stabs somebody with a knife, there are certain elements of how it's defined, and it doesn't matter if it's a little girl who had a knife and she was trying to defend herself perhaps against this big bruiser, and she ends up stabbing him. If the technical definitions are in there, it may or may not apply depending on what happened, but it doesn't matter whether it's a sympathetic girl, and of course she has a defense of self-defense perhaps, or perhaps not, but it doesn't matter if it's a little girl or some, multiple previously convicted murderer who got out and is now, terrorizing the town. It doesn't matter. At the point where we decide if there's a crime or not, it doesn't matter. At the point where there might be a defense, like a self-defense, that starts to come in. But for the sentencing, we do pay attention to the different equities involved, but the equities do not get involved in the application of law. So sometimes it fits and sometimes it doesn't. Sometimes it just feels really unfair, and other times it's absolutely right. But it's like check marks. Do we have the check marks? And when a lawyer goes into court, they have to prove this objective law. The other side's trying to erase the check marks. We're trying to check. No, erase. You don't have this one, because in the law, if you don't have every single check mark, you don't get to the finish line. You cannot be convicted of that crime. You just can't be. It didn't happen.
Judge, you mentioned. I'm sorry. Go ahead. You mentioned the difference between technicalities and kind of matters of law, things like that. I remember in law school, I think my classmates and I were surprised to learn the relationship between a jury question and a judge question, a matter of law. Would you be able to please maybe elaborate on those differences and what the responsibility of a juror is compared to a judge?
Okay, again, civil versus criminal, it makes a difference. Normally, the jurors only decide questions of fact. So they decide whether or not the plaintiff in a civil case or the prosecutor in a criminal case have met the burden of proof. Of course, it's beyond a reasonable doubt in criminal, as you hear it on all the TV and movies, and it's only a preponderance on the civil side. But jurors never decide the sentence except in one instance, and that actually is the toughest of all. That's in a death penalty case, in a capital case. Then they have the obligation, if they've met certain criteria, if they found beyond a reasonable doubt that there's special circumstances, then it kicks into a penalty phase and they decide the penalty. But otherwise, they do not. They have nothing to say, no input at all. I suppose, at times there were times in my life on the bench where the jurors wanted to recommend mercy. Actually, after they know, Judge, we know you're not asking us what the sentence should be, but even though we convicted this person, we really think that you should give him a break. But that's all informal. It's not set up in the structure. The structure itself, the jurors never decide the law in criminal, the penalty in criminal. In the civil side, there are some things that are decided only by the judge. And there's some things that are decided, usually factual things that are decided by the jurors. And then the jurors in that case, in a sense, do decide the penalty because they decide how much money. Civil is only about the money, right? At least in terms of the law, unless it's probate or family or whatever. It's just about money.
And that's why the standard of evidence is lower. Is that right? Because your freedom's not at stake. Okay. Your
freedom's not at stake. And it's interesting because this is one of the things that happened too. We had some heavy duty budget cuts some years ago. And I think part of it was because the California seemed to want that magic train. Remember that magic train?
Yeah. The smart one, or the
one that was supposed to go from LA to San Francisco that has somehow disappeared off the horizon. I don't know. But
trains they're not very popular in the era of COVID, I would imagine, right?
Yeah, that's a whole nother layer, right? It's a whole nother layer. But so in the civil, the budgets were cut tremendously. In the civil side, we lost court reporters, we lost bailiffs, we lost staff support, stuff like that. In the criminal side, you are dealing, just like you said, we're dealing with people's lives and freedom. So they didn't take away the budget. They had budget cuts, but not as seriously as they have had, trying to protect it. And of course, with COVID and the court shut down, it's been a disaster because you have people's literally their freedom. They are in custody, assumed to be innocent, waiting. And my understanding is about 7,000 criminal trials stacked ready to go. And they have an absolute right to have a decision. Yeah. Interestingly enough, I'll tell you, one of the conversations that I recently heard was, if you have a right to a jury trial, it's guaranteed by our Constitution. You have a right of confrontation, you have the right of silence, all that stuff. But
Judge, sorry, just to explain, what is the right of confrontation?
You have the right to confront and see and question the person who's accusing you of a crime. If someone has claimed that you stole those golf clubs, you have a right to confront Father Richard. Whoever claims that they saw you sneaking out the back with the golf clubs, you have a right to do that. They can't just, they might be able to do it circumstantially, but you have a right to confront the evidence and challenge it and to make sure that the prosecution can prove it beyond a reasonable doubt, or you're supposed to be acquitted. Now, acquittal doesn't mean you're innocent. It just means they didn't convict you. There is no innocence verdict in the court setting, which is kind of interesting. So with respect to what the jurors do, they will be listening to the evidence. The defendant has the right to remain silent. They don't have to say anything. Although I think the problem is, I think most people figure, well, if you really didn't do it, you'd get up and say so, right? But there may be many reasons why you may not you may not want to take the stand. You may not want to subject yourself to having other things brought up. And it just becomes a strategy question. But by law, you are absolutely protected. So we now have 7,000 criminal cases. That's the last number I heard.
Wow.
To go to trial.
Wow.
Then the question is a Zoom trial a jury trial? Is that the same as are we satisfying your constitutional rights? I don't know.
Now that sounds to me like the kind of question that we might be hearing the Supreme Court of either a state or some circuit courts weigh in on. Does that sound right to you?
I think so, because someone's going to challenge it. Someone's going to challenge it if they do proceed by way of it. But on the other hand, if there's no other way to get you to a trial, because we have to have the social distancing, we don't have courtrooms that are large enough. There are a lot of issues that come up with respect to how to actually manage and put on a court trial or a jury trial. We have judges who are trained in criminal. We have judges who are trained in civil. Currently, the LA Superior Court has cross-trained. So theoretically, we could spread every criminal case that needs to be heard through the courts. But if we don't have the space and we don't have the bailiffs, we don't have the lockup rooms to bring them for security purposes, it's a pure logistical nightmare.
Now, so taking a question like that, so whether a Zoom trial is sufficient to meet your constitutional rights, that sounds like the kind of question that a jury is not qualified to answer because it's a matter of law. So would you be able to go into a little depth about why you have juries at the trial level, but you don't have them on appeal, and you certainly don't have them at the highest appellate level?
Right. Well, we on both federal and civil, we do have juries, right, on the trial court level. So you have 12 people, or in the federal court, it might be 8 people or 6 people. They make the decision as to whether or not, and they make the fact-finding decisions. When we go to the Court of Appeal, we're not talking about what we call a de novo trial. We're not talking about having them decide the case and listening to the witnesses and deciding whether the evidence is. They just look to see whether or not the burden was met, that the evidence was sufficient to support what those jurors did. They don't start it over again. You don't get a do-over. It's not a do-over there. It's whether or not your constitutional rights were protected, whether the law was followed. And that takes either an appellate panel, or it could be, it's always a panel, or it could be a Supreme Court panel that decides. And of course, it's either 5-4 if it's, you have to have at least 5 to make it in the Supreme Court, and then you have to have at least 4 out of the 7 to make it in the state court. So yeah, there's no jurors there, because the point is not to decide what happened. The point is, was the law followed?
That's interesting. I remember I thought that was fascinating in law school when I learned about that. Just at the appellate level, when you're deciding matters of law, you have these, like you're saying, different standards of review, and how influential those can be in evaluating the claims of either a criminal defendant who's appealing, or the state who's appealing, or a civil defendant. I'm thinking it's likely that at least some of us here will serve on juries in the next few years. As a judge, I hope so, right? Is there anything you would want to emphasize to a pool of prospective jurors hoping to serve that capacity effectively?
Yeah, I have a lot. I think our system has changed, and it's because, in a sense, it's because of the world that your generation confronts that mine did not have, and that's access to information. So our entire system of justice is based on the fact that we promise those who are accused, or those who come to court for redress, we promise them, these are the rules that have to be followed. If you can meet these rules, this is what the result's going to be. Not guilty, liable, the range of a maybe money awards is this amount, but it's all a set of objective law. But we're all basing it on, the same square corners of the courtroom. We fight as lawyers. We fight over what's going to come in. I want to make sure that when Tom Cavanaugh is charged, People versus Tom Cavanaugh, for these golf clubs, that Tom Cavanaugh's 3 DUI convictions when he was 15 do not come in, because they have nothing to do with whether he stole these golf clubs or not. Nothing to do with them at all.
And Judge, what would you do if you're walking out of your chambers one day and you're accosted by a juror who says, "I learned about Tom's DUIs. What do you have to do there? Is that a mistrial?
Well, it could be a mistrial if he told other people about it. We would have a hearing. He'd be taken off the case. Most likely. I mean, we'd have to have an examination to say, well, can you still be fair? Can you treat Tom the same as if you had not heard this? Like, right, sure. I don't think so. But they're not supposed to consider anything but what has been presented so that everybody has a chance to challenge it. We have what are called in limine motions, where as attorneys, they fight over what gets to be allowed in. Judge, I think I should be able to get in the fact that he's got 3 DUI priors because it affects his credibility. And he's claiming that the other people are lying and we get to challenge his credit. No, that's not, it's inflammatory. It really is not related. And we fight over this stuff. We have a lot of case law, a lot of precedent that involves with that, but we fight over which questions are going to be allowed and what's going to be presented to the jurors within the 4 walls. And then the judge defines what the law is for them. And then the jurors go and decide. They decide the facts, and then they decide if it fits in that law or not.
That's
Now,
it.
you have the internet, though. You have the internet.
Right.
You know you're going to look it up. I mean, I think one of the problems I have today is because of the access to the internet. It's really hard to get people to follow the rules and not to go. You can go on the internet afterwards. Go afterwards. That's fine, but you can't let it affect you because it's hurting somebody.
Yeah.
Tom is either not getting a fair trial because they found him drunk on one of his Instagram pages having a real good time at a party. It has nothing to do with it. Maybe that wasn't even his party. Maybe he was pretending that day. And if his lawyer knew that the jurors were looking at this picture of Tom being drunk, they could explain, hey, this was a fake. It was a stooge. They were just pretending so that they could surprise his roommate, but let me explain that it's not what it looks like, at least to keep it even. We have no opportunity to explain when somebody goes on the internet and looks.
Yeah.
And we explain, you're not allowed to go, you're not allowed to go, you're not allowed to go. And, almost every decision that's made by you, probably, Tom, I'm sure, you go to the doctors, you get a rash, you look it up on WebMD, you go to a new restaurant, you check out who's the mixologist and what cocktail you're going to order and which dessert to order in advance. No, you don't want to order that appetizer because it's got terrible reviews or whatever it might. We look up everything, right? And now we walk into this 4 walls of the courtroom where we're told you can't do that. And yet what I find, one of the driving factors, I think it's a generational thing between your generation and mine, perhaps, is that if we were told a stupid rule, like the judge says a stupid rule, that's a stupid rule, but the judge told us we better follow it.
Yeah.
I think the younger jurors, the inclination is that's a stupid rule. I'm not going to follow that. I want to get it right. I want to make sure that these lawyers are going to, I mean, I know they're not going to tell me the truth, and I want to make sure I figure out who's the right person, who deserves justice. By language of what I'm talking about, that's purely subjective, right? It's subjective. My view of who I think deserves it. It's different than what the law says. And in the structure of the law, as a judge, I may think something seems unfair. I may think somebody deserves a break, but that's what I get to decide as a judge after the jurors decide if there was a violation of a law, if there was a crime committed by this person. And then I apply the equity, but you're not supposed to be dealing with the equity side. You are on the civil, but not on the criminal. But it's all supposed to be within these facts that we've decided are going to come in, excluding the facts that are not going to come in, dealing with the law, not making up the law because you think the law is better. I've told jurors many times, if you have a gun case, and you have some jurors who are NRA members and they have a complete collection, maybe they have an arsenal, and then you have people who are totally anti-gun, they hate them, whatever. Those jurors should still be able to come to a verdict because their question that they're being asked is, does the evidence meet this law? They don't get to question this law. They're not supposed to.
Yeah. Well, I think
when they do, but that's the problem. We shouldn't have that problem, but because of the internet and the access to information and the need, I think, of people to get it right, which is subjective, be a problem.
Your comments here, Judge, really speak to your integrity in keeping these proceedings within those 4 walls and playing by the rules, even maybe when the results might not go exactly the way you would like. You still have to play by the rules.
Right.
What kind of qualities should we pay attention to when we vote for judges on the ballot and in getting judges such as yourself who are concerned with presiding over non-prejudicial trials?
Okay, I think in the judicial setting, it's not supposed to be political. You're not supposed to look for the Democrat judge. You're not supposed to look
Mhm.
for the Republican judge. That has nothing to do with what we do. And in fact, if we start thinking that way, we've destroyed the whole premise of our independence. So I think what a person needs to look for, and you can go to the state bar and see how they've been qualified, well qualified, not qualified, qualified, whatever it might be. But there's ratings that are given. You can ask friends who are in the system. But basically, you're looking for people of integrity, and I think you need people with experience. It scares the heck out of me when, and this happens periodically, and these are very smart people. But when you have somebody who goes into a situation on the appellate side, or goes into a courtroom, they've never done a trial,
Mhm.
that
Mhm.
worries me a little bit, because
Yeah.
there are practical sides that don't quite work in the pristine academic world that of how we think it should work. In the real world, it doesn't quite always turn out that way. So we look for experience. So, for example, if there's a judge who has applied, this is two ways to become a judge. One is to make an application with the state, with the governor, and then they vet you, and you get appointed or you're not appointed. If you can't go that route, or you don't, maybe you've tried and it hasn't worked, or you just decide you're going to run. This is where we see the judges on our ballots. I think there's 3 right now on the ballots. They run. They are still vetted by the U.S. or the state supreme or the state bar, and you can go online and find out what their bar results or the bar categories or evaluations are. But you don't know a lot about them. But I think integrity is everything, and experience. And so, for example, if that potential judge, the candidate, has lied about their credentials, that's
Mhm.
kind of a big deal.
Mhm.
If they've claimed, well, I've done this and I've done that, it turns out, yeah, for 5 minutes you did that, or
Mhm. Mhm.
you're actually conflating or inflating a volunteer job you had one time, and you claim that this is, kind of your mission in life.
Mhm.
That kind of integrity issue, I think, is something that as a juror, I mean, as a voter, I'd want to know. How you find out, it's almost impossible other than to ask
Mhm.
in the courts, call me, ask, go look on the bar sites, see what the endorsements are in the papers, and find out what the reason is, and then try to do a little bit of work. And if you just don't know, don't vote.
Yeah. Okay.
I think what happens, we've had really good judges who've lost because people didn't know who they were. And it's impossible for us to put just whatever money it would take to make sure that Tom Cavanaugh and your whole class knows who I am. We don't have that kind of money. And
Right.
to reach
Right.
everyone, it doesn't work. But um, oftentimes what would happen is somebody with a bad name would lose. If it was an odd name, or it was a little ethnic name or something else,
Mhm.
and they might lose to someone who has, like, I can say my 25 years on the bench, I never got challenged. I think I have a great name, Connor. Who can be offended by Connor, right? As opposed to friends of mine who've been absolutely outstanding, brilliant judges who've lost because they had an odd name.
Mhm. That's
So other
unfortunate.
people don't vote for, I would not want you to vote for me if I was in the ballot just because of my name. Find out about
Right.
me, or find out about the
Right.
other side. But
And I mean, I imagine, Judge, part of that, you're talking about campaigning. Unlike politicians, sometimes these judges don't have the time to be campaigning because they're in the courtroom deciding these cases already, right? For a retention election or something like that.
yeah. Well, we don't have the time. We usually have campaign managers that somebody will hire one if you're running, or if someone's challenging you, you better run, because I mean, you have to get out there and defend yourself. But it's really an awkward situation, I find. Who are the people that know us? They're the lawyers. So we go and
Yeah.
ask lawyers for money. That isn't that kind of a conflict right there?
Yeah.
To
Yeah.
have the very lawyers who want us to give independent decisions. They don't really, they want a decision in their favor, but to give money, it becomes a real difficult thing. And it's hard, I think, for judges to go out and ask for the
Mhm.
money, knowing that when that same person who's donated 10,000 or 100,000 or 50, 500,000 for them in their campaign, um,
Yeah.
it
Well,
becomes tough. So as we judges, what we often do is we will pull together and we will donate money towards somebody who's gotten challenged, because
huh,
that whole system compromises all of us when
right.
somebody is challenged because of a particular decision. We've got to have independent judges who are not afraid of having somebody take their job from them by
Yeah.
challenging them, even if there was a mistake. There's ways to deal with the bad judges. They get reported to the Commission on Judicial Performance. There's things to do that you can do, but to do it in the ballot box, I think is a real can of worms, and it's a slippery slope and very, very dangerous, I think.
So thank you for those comments. I think it sounds like we've addressed, at least relatively sufficiently, some of the technical details. And I know people are looking forward to hearing about your personal experience on the bench.
Probably not.
Well, I certainly am. So I was hoping you might be able to answer some questions. First, what drew you to the profession of law generally? And then second, what did you find attractive about the opportunity to serve on the bench? And maybe some context here for people less familiar. Serving on the bench can be a less lucrative, but a more honorable position in the position of law. So would you explain some of your rationale there? Because I think people should know that for a lot of judges, it comes in hand with a significant financial.
Yeah, we are often the least paid person in the courtroom.
Right. Yeah.
You don't go in there to make money. In fact, if you want to make money, you don't become a judge. But my way, I never wanted to be a lawyer. I never wanted to be a judge. But I didn't grow up in this country. I grew up in Japan. So when I first came to the States, I went to SC. I mean, I can't go to UCLA because I wasn't a citizen. SC was actually the closest college to me, and believe it or not.
Wow.
My brother had gone there. There were 5 of us at SC at one point, but so my brother comes back and says, "Oh, you got to go to SC," and I ended up going to SC, and it was a real culture shock because I looked like I fit, but I didn't fit at all. I had no idea, and I decided I got ripped off at a gas station. I decided I need to learn the rules of my country because I can survive in Japan, but I didn't know how to survive in LA. So I decided, okay, this is on my list. I'm going to go to law school, but not because I wanted to be a lawyer. And at the end of the, I went to SC Law School too, the same Zoom School of Law that you're going to right now.
The Zoom School of Law, yeah.
And then at the end of that, I was interviewing, and I wasn't finding very many happy lawyers. Most lawyers, it just seems you go to a cocktail party and they're complaining about the law, or they're trying to figure out how to get out of this or how to go into something more creative. Some people love what they do, but for the most part, it's a world of fighting. It's a world of dispute. That's why we exist. So I was doing interviewing and kind of didn't like what was coming up, and then finally said, because I didn't have any connections, I didn't know anybody. Somebody said, "Hey, you ought to go down the DA's office. They're interviewing." I'm thinking, I don't see myself as a trial lawyer. I mean, I don't like public speaking necessarily. And I went down there, and there's the first place where I saw that they loved what they did. They were friendly to each other. They weren't ripping out cases in the library books so that nobody. Right. Now you get it online, but in the old days you could rip the case that you're looking for is missing because somebody ripped it out of the book, so you wouldn't get it.
Hence a result of a strict curve, right?
Oh man. Anyway, so I ended up going there, and in those days, they didn't have much of a training program. So within about maybe 2 weeks, I was doing my first burglary trial, and I didn't know what I was doing. And I promptly lost it as I should have. But I was even calling the defendant the alleged defendant. I didn't know if I could I was allowed to call him the defendant until he was convicted.
Yeah.
It's crazy, but I loved it. Turns out it's creative. To me, it was the place where you have the most connection with the real world, as opposed to just sitting in an office, writing a contract or deciding what somebody's will looks like, or doing some mergers between companies or whatever. I just loved it. And after 10 years, I was starting to get pushed into administration, and I didn't want to go into administration. So just, God's hand. Our governor at the time was George Deukmejian, who liked prosecutors, and he was appointing prosecutors. So I applied, just fill in the paperwork, applied, and I ended up getting on the bench. And 25 years later,
wow,
I just love.
We're lucky. We're all lucky you filled out that application.
Well, half of the people are lucky.
So it looks like we have an interesting question here from the audience.
Okay.
So from Father Richard, actually, I'll
trigger
it.
Father Richard.
Cool.
You guys are so lucky to have Father Richard.
Is there a system that either public system or an internal judicial system, or do judges just correct one another when they get out of line, dealing with integrity issues that arise when judges act not like you were explaining within the boundaries, not playing by the rules, but as activist judges trying to seek the result that they think, for whatever reason, is best, regardless of what the technical law says on the issue?
Let me address that in two different parts. One is that we do have the Commission on Judicial Performance, the CJP. If anybody thinks that the judge has violated the rules or denied them their constitutional rights or whatever, they can file a complaint with the CJP, and the CJP will investigate it. That CJP is made up of civilian members and judicial members appointed by the governor, appointed by the different courts, and they will take a look, and they can actually remove a judge. They will do that, or they can just they can have a public hearing. They can do it privately. They can send what they call a zinger letter, where they admonish the judge, and if there's enough violations that come up, that judge can actually be removed. In terms of being an activist, that's in the news so much, when this thing with both Kavanaugh, with any judge, going back to even the confirmation hearings for Ruth Bader Ginsburg. Yep. We as judges are not allowed to prejudge a case. We are not allowed to be activists. We have to. We're all about the check marks. Was this proven? Was this proven? This is what the rule is. This is how we interpret the rule. This is how this sentence is what it means within the context of these facts. This is what this phrase is interpreted to mean. We're not allowed by our ethics, by the rules of our jobs, to be activists. We're not allowed to do that. In fact, one of the things that I've never forgotten is, if my values, if my beliefs, separate from religious beliefs or my faith, just be my opinion about anything, if my opinions interfere with my ability to be neutral on deciding whether or not this word fits within the context of the legislation that was passed by our senators or by our Congress people, we're not allowed to do that. We're supposed to follow. We're supposed to recuse ourselves if we cannot follow the activist judges. Are kind of a violation of the whole structure of how we become independent and why you should trust us.
Right.
We're following. If you want to change the rules, if you want to change the law, there's a lot of ways to do that. You talk to your senator. You go propose legislation. You put up a proposition on the ballot. You can change the law, but it's not in a courtroom.
Yeah.
That is not where law is made. That's exactly what we're not supposed to do. And if we can't, we need to step aside. That's our obligations. We should step aside if we can't.
Yeah. And Judge Cavanaugh, you talked about making law. I have two questions before we get to an interesting question posed by an audience member. First, if judges don't make the law, who does? And if you run into law that you disagree with but have to apply, have you encountered situations in which you felt that your faith and your professional obligations have conflicted with one another?
Okay, so who makes the law? Our legislators make the law. These are the people you vote for, which is why when you're voting for a congressman or a senator, they are making the law. So you want to make sure that you are voting for people that you trust. And it may be that, in a way, we don't always know what they find out once they get there. It may be that there's different sets of information. So something that looks like it's so obvious that there ought to be a law that says this. In the big picture, it may look a little different. So you really do have to trust the integrity of who you're voting for, because they are the ones making the law. You can go out and get the signatures that are necessary and create your own with a proposition. Oftentimes these propositions, how many do we have on the ballot this time? 26?
Something like that, yeah.
20s, they're not quite 30 yet, but you can just go out and get signatures and you can actually do it yourself. If it turns out there's something about that law that doesn't fit within the Constitution, then it actually comes to the courts. And we'll say, this is the violation of the victim's rights or person's rights to this, that, or the other thing. And it goes into the courts to whittle it down if it looks like it's not within the protections of the Constitution. But it's all within the framework of our Constitution, of prior law, of regulations that have been passed and that are part and parcel. If somebody challenges, they can challenge it. But in the courts, we don't make it. So then the second part of that was in terms of its impact on my faith. My faith has kept me going in this because you mentioned that I started the sexual assault unit in the DA's office. And the thing that we did that was different that I was part of was that I created this system that had vertical prosecution. Normally, the police come in, they'll take it to a DA. There's a DA who's a filing deputy who will decide whether or not we file charges against this person. And then it goes to the DA who's going to try the case, probably a supervisor. Then it goes to the DA who actually tries the case. We have the cops who do the investigation, the cop on the scene. Then there's an investigating officer who's a detective that runs the show and presents it to the DA. There's a lot of different people on there. So you can imagine if you're the rape victim or child molest victim or the victim of any crime, you're talking to a lot of people telling your story over and over and over and over again. So we wanted to do a vertical prosecution where it was the same person. They would tell the DA, one DA all the way through, and that they wouldn't keep explaining it over and over again. So that's kind of what I did. I lost a lot of cases because people didn't quite, this is way before Me Too, and it's way before, I mean, it was just a different world. So I had cases where I thought, if I was a student, I would have been stupid enough, and I would have probably been the victim in a similar. I'll give you an example of one where this woman, this young girl, she was a college student. She went into, she was having problems with her car. She went into a gas station, and the gas attendant says, he's the owner of the gas station, this is in Westwood, takes a look at the car and says, you need new hoses. She goes, okay. So she calls up her boyfriend to say, he says I need new hoses. Do you think that's right? And he goes, yeah, you do. I told you that before. Remember 6 months ago, I told you need new hoses. Okay. I'll have him do that. So she goes back and she knows that the owner has seen her talking to her boyfriend. The owner says, okay, fine, we'll take it, but we have to order them from our other station that's in another city. So it's going to take a couple of hours. I don't have any place to wait, but if you'd like to wait, I have a condo down the block. Hey, look at that face. See, you had that face. As soon as he's a condo down the block, oh yeah, right. So this girl's thinking, and that would have been me. I would have gone. I know he's the owner, so we know who he is. He's seen me talking to my boyfriend. Other people have seen me here. There's no way anything bad can happen. I'm just going to wait there while the hose comes. Of course, she ends up getting assaulted. And I was thinking I would have probably been a sucker enough to have thought, oh, what a nice thing to do. And then, of course, as soon as anybody hears I've got a condo down the street, the eyeballs go up, the eyebrows. And of course, his defense was that it was consensual. He comes into court. He's got his wife in the front row and his kids, beautiful family. I lost the case. That was hard. And where the faith comes in is that I knew that maybe justice wasn't happening here, but it wasn't going to go unnoticed. It wasn't just disappear. That's where my faith came in, because there were a lot of cases that I couldn't prove beyond a reasonable doubt. I just couldn't. Just was that way. And then there was another case that I had that was problematic. I told you about this earlier, but it involved this kid who was a college student. He had left the neighborhood. He was Black. He was in a bad neighborhood. His father had gotten him out. He was set up in college. His dad had bought him a car, and he was doing okay. He was doing pretty well. And he went back to the old neighborhood to visit his grandmother. And one of the tough guys in the neighborhood came up, and they were talking. And he's just there. And the tough guy says, look over there. This turned out to be a gang member. Look at that car over there. Look at those great wheels that he's got. And he talks the college kid into driving with him to take a closer look at the wheels of this car. Well, it turns out that it was an enemy of the gang member, and he ends up using this college boy's car as the stalker, I guess. Anyway, they catch up to their car, and he ends up shooting and killing the driver of that car. So now we have this college student's an accessory. He's an accessory to murder, which is that he's also theoretically liable for first-degree murder. He got convicted of first-degree murder. The jurors didn't believe it, that he didn't know. I believed him. Then the quandary I was in, I don't make up the sentence. I'm given a prescription. For murder, it's a little bit different, but in most criminal cases, there's a penal code that says for every crime, whether it's a shoplift or felonies anyway, there's a low, middle, and a high. So if someone deserves a break, you give them the low, or you can put them on probation depending on what's allowed or not. In this case, for this kid, I had two options: 0 time or 25 years to life. It was the only option I had. I didn't have anything in between.
Those aren't precise instruments.
So I wasn't going to I couldn't do 25. I thought 0 was probably too light, but 25 years was too much. So I gave him 0. And on the political side, if I had been wrong, I hadn't geared this guy like I thought that I had been fooled. and he went and committed another murder, that would probably been the end of my job, because the headlines would be prior murder strikes again, judge let him off. And someone would challenge me and I'd get defeated, and that'd be the end of my career. So it was just a trust issue, but I went with my gut and I gave him 0. He's doing fine. He's doing fine. He did okay. So that turned out to be. But for the most part, the faith is the understanding that even if it doesn't seem like justice, and for the people who are involved in the system, I think it rarely feels like justice, because it's a brutal, this advocate, or the whole idea of adversary system, that you can attack the other side and you can bring in whatever you can to dirty up the other side, especially in the civil case. It gets pretty ferocious. The fight over money is very, very ferocious. It feels pretty bad. It doesn't feel like justice. And sometimes it isn't justice, but ultimately justice will happen. It may not happen in the courtroom. So
well, God bless you for those compelling experiences. And I mean, what a difference you can make in these people's lives. More, I mean, you really, this question of whether they're going to live through their youth is really coming down to you. So we're lucky to have people like you on the bench. So thank you, Judge. Looks like we have a question here from a current law student asking on a lighter note, asking about what your favorite class was in law school.
I like contracts, because I had a really good teacher. I like contracts. It just made sense. Taxes, I hated tax. I did enjoy moot court. I thought moot court was pretty fun, but that's not.
Do you like taxes any more as a taxpayer than you did as a law student, or?
I don't understand taxes. I don't understand bankruptcies or some things. And by the way, I did mention this with Tom before, so I got to say it again. So 25 years on the bench, 10 years as a trial lawyer. Now I'm going on 9 years. My new mission in life as a mediator is to keep people out of court, because it's like nothing good comes out of court. But, I don't think there's not much that I do in my life as a lawyer that I got out of law school. It's just law school's theory, and it's learning how to think, it's learning how to analyze, it's critical. But once you get out there, depending on whether you go to probate or whatever, maybe the only thing that stuck for a while was evidence class, because evidence does still apply. But
it's a good class. Yeah,
I liked evidence. It makes sense. But it's also, some people look at the evidence code as a manual on how to keep stuff out, how to keep the bad stuff out. And I'll tell you, this is something too. This is it just makes me laugh, and it's such a genius. But a millennial juror gave a definition of a legal objection. Now, as lawyers, we're supposed to object. We're advocates. We're supposed to object if someone's coloring outside the line, so to speak. You got to stay in the line. You got to stay in line. The judge ruled this. The judge said this. This is what the law says. Whatever. So objection is coloring outside the lines. This millennial juror said an objection is the noise that comes out of a lawyer's mouth when the truth is about to leak.
I'm taking a trial advocacy class right now, and deposition strategies, and I can kind of endorse that definition.
Yeah, but then again, that means you're looking for the leaks as opposed to trying to color or stay within the lines of the coloring book. The law promises the parties, the one who's being accused, the one who is accusing, the plaintiff, the victim. We promise them we're going to go with this set of laws, but because of the access to the internet and the fact that people kind of want to figure it out for themselves, it really puts the integrity of our system in jeopardy. Be glad I'm retired. This is now your world, Tom. You have to figure it out. Like, what do you say to a juror? Okay, ladies and gentlemen, the juror, if you find something online and it helps our case, don't say anything. But if you find something that hurts us, please let me know, because I need to explain it doesn't apply here. That's the wrong person, or that's a different state law, or how do you deal with that? This is a real challenge.
Judge, I had a question kind of related to that. When obviously you were more on the prosecution side when you were coming out of law school.
Yeah.
But what would you say to someone who asks, after seeing a particularly heinous crime, why does this person deserve a defense? How could you represent them? How do you even do it? Why does our system focus so much on creating a proceeding which won't prejudice them?
Well, there's a standard answer, and I will tell you, when I applied for the DA's office, I could have gone to the public defender. I could have gone either
Right.
way. They just called me first. DA's called me first. Because there's a camaraderie between at least there was in the old days, I hope there still is, between the defense attorneys, the public defenders, and the
Mhm.
DAs. Um, we had great friendships in there, but from the public defender side, our job as the DA, my job was to see that justice was done. And that included
Right.
the fact that if I thought somebody didn't do it, my obligation, my mission was to not file that case, to let it go, or to drop it down, or to withdraw the prosecution of the case. The job of the defense attorney is to defend that person and make sure that the prosecutor is following the rules. So whether you think the client did it or not is irrelevant for the purposes of what you're doing. It's
Okay.
to
Right.
make sure that everybody jumps through the hoops, that the Constitution is followed, that the jurors follow the law, and hopefully they can either get the guy off or they can make sure that justice is done. And
Yeah.
integrity counts for a lot. So if I had a public defender or a defense attorney come in, and this is a person with integrity, I trusted him, because if that person, she said or he said, this is the real story behind my client, and I trusted them, that made a difference. That made a
Hmm.
difference to
Hmm.
me. The integrity, and we call it getting a jacket as a DA. If you get caught being a little sleazy, you're hiding evidence, or you're
Hmm.
twisting the truth a little bit just to get a conviction, because our job is not to get a conviction. Our job is to see that justice is done, and that includes
Right.
acquittals if that's the appropriate end result. But you get a jacket for being shady, and you
Right.
keep that. Once you get a jacket, you got a jacket for life, and that goes to both sides. Integrity is so critical,
Yeah.
especially in the criminal side, where we all have to work with each other over and over and
Right.
over.
It's interesting because sometimes you look at other judicial systems in other countries that are a little more collaborative instead of adversarial. And I've always thought the kind of crucible of the adversarial system, with two attorneys pressing advantages and really, really zealously advocating for their clients, in a way comports with a more capitalist sense of try to obtain the value, and in the end we reach a result if both people are trying their best that's better for everyone, because the truth might
Everything's
be
on
out.
the table. So
Yeah.
everything's on the table, so you can see it all, as opposed to an uneven battle where one side is just running circles around the other side.
Right.
There's not much justice in that
Right.
situation. Or maybe where you have someone who's got an agenda, or who's been paid off, or who has strong feelings or wants a certain result. Which I
And
think,
then I see we only have a couple minutes left here. On a final note, if you could, what advice would you have given yourself as either an aspiring law student or an aspiring lawyer when you were a law student, right now, looking back on a successful and fruitful career?
I would touch back on what I said earlier. Is I would have told myself, if I could have, to really enjoy the process, because you are first and foremost learning a way of analyzing. You're learning how to look at information, read information, analyze it, take both sides, be able to try to drill down and look at the core of what the real value is of what you're doing. And then at the end of the day, you're able to take a step back and be able to see the big picture.
Mm.
The best
Yep.
attorneys can argue both sides. In a sense that makes it strips us of our morality sometimes, because we no longer see things in black and white. We see things
Right.
in a lot of grays, which is what we're trained to do. So like, it's like somebody can say something. I think of Chinese, it's like the sound O. You can say it 5 different ways, and I can only hear 3 of them because I can't hear the others. But
Right.
there's a lot of different ways to look at something, and we will find a way. How can you interpret 3 different ways? Well, we lawyers have figured out a way, because that's how we're trained to do it. That's
Yeah.
the good part. That's good. That's the part we should really be happy about, and don't worry when there's just no answer. I used to hate it. Just
Mhm.
tell us the answer, professor. Tell us the answer, right? They never
Definitely.
tell you the
Definitely.
answer. Well, that's the point of law
Right.
school.
Right.
Enjoy
Yeah.
it.
Sure.
Enjoy it.
Well, I'd like to first of all thank you, Judge Connor. This has been a remarkable conversation, and I hope our audience has garnered some level of understanding about the judiciary and our role in preserving it. And I thank you for joining us. I'd also like to thank everyone else in the audience for attending today on this Sunday afternoon. I know that this recording will be available in the next 3 days on the USC Catholic Center website. So if you'd like to rewatch it or share with some friends, I'm sure we'd appreciate that, and hopefully they will too.
Great. Well, thank you very much, Tom. It's awesome. The Catholic Center is just a shout out. What a phenomenal.
What a great place.
Didn't
Yeah.
have it when I was there. I wish they had.
Yeah, I find I've written many a brief. I've started my citations at 9 p.m. the night before it's due in the Catholic Center Library.